Hello, I'm Nadia MacLeod from RP Emery Legal Kits, and we help you cut your legal costs with our online template kits. It may seem like a generous act of goodwill to allow your tenant to move in before finalising your lease, but this decision to rely on a verbal lease can have big consequences for you down the track. The main issue is that your tenant will automatically be given minimum rights and obligations under the law if they move in and start paying rent without a written lease in place. Secondly, the tenant may lose the motivation to sign the lease if they've already moved in. And thirdly, you will have enormous difficulty proving what the lease terms are if a dispute arises. For more detail about the consequences of these three issues, you can read our article by clicking on the link below. The rights and obligations of residential tenants are prescribed by law and set out in the residential tenancies legislation in each state. You cannot contract out of these terms, however, you can add to them. A written lease is recommended to cement any additional verbal terms you have agreed to with your tenant. If the tenant has moved into your premises and has started to pay rent without signing a formal lease, it may be a valid, periodic or fixed-term tenancy which will confer certain rights and obligations upon both the tenant and the landlord. It is highly recommended that you finalise the terms of your lease and put the terms in writing before letting the tenant take possession of the property. RP Emery offers Australian residential tenancy lease agreement templates which comply with the residential tenancies legislation for each state or territory. Visit the link below for more information.